Good morning, everyone, and welcome to our webinar today. My name is Simone Brew. I'm a principal in the Environmental Planning and Local Government Group. Today, I'd like to introduce you to Shawn Skyring. Shawn is a principal at Matthews Folbigg as well in our Workplace Relations Group. Shawn has over 15 years' experience in advising local councils in relation to all aspects of employment law. So welcome, Shawn.
Thank you, Simone. Today, we'll be presenting on how to deal with disciplinary action against employees. Firstly, we'll talk about the requirements for council employees under the Code of Conduct, and we'll clarify what constitutes a breach. And then we'll go on to deal with legislation and awards that apply to council employees and how to appropriately follow disciplinary procedures in place to ensure procedural fairness, to avoid unfair dismissal claims and industrial disputation in the workplace.
All right, well, with my governance background, I can start with the Code of Conduct. So in addition to their contracts of employment, council employees are obliged to comply with practical, prescribed, ethical and behavioural standards in the performance of their role. And that's unlike many other employees who work for other organisations. These standards are prescribed under the Model Code of Conduct, and of course all councils have adopted the Code of Conduct in differing forms. Council employees do come within the definition of a council official for the purposes of the code. Now, each Code of Conduct sets out the following: principles underpinning good relationships and behaviour. They provide a framework to guide and support best ethical practice. They provide a procedure for addressing alleged contraventions of the code, and we'll talk about that today, and assist councils to get on with the core business for which they exist, which is in effect serving the community. So, Shawn, let's start with the code. Are there any behaviours that are forbidden under the code?
Thank you, Simone. It's a long list, but it's necessary for me to go through it. Council employees must not act in any way that is likely to bring councils into disrepute. Any behaviour that contravenes the Local Government Act and its regulations, council's relevant administrative requirements and policies, is detrimental to council's principles identified in the Local Government Act, is improper or unethical behaviour,
right,
is an abuse of power or otherwise amounts to misconduct, involves intimidation, harassment, verbal abuse, discrimination, disadvantage or adverse treatment in relation to employment.
Okay, is there anything else?
Yes, there is, Simone. Anything that comprises prejudice in the provision of services to the community. Employees must not expect or request preferential treatment in relation to their dealings with council in their personal capacity or use their position to influence other council officials in the performance of their public or professional duties, to obtain a private benefit for themselves or for anybody else. In addition, they must not make complaints improperly, take detrimental action in response to complaints about standards of behaviour, or disclose information about codes of conduct matters.
Right. All right, well, what I might do now is explain the behaviours that are required under the code for council employees. There are a lot of obligations on council employees pursuant to the Code of Conduct. They must act lawfully, honestly, and exercise a reasonable degree of care and diligence in carrying out their duties. They must treat each other with respect at all times. They must consider issues consistently, promptly and fairly, and in particular, ensure that development decisions are properly made and that parties involved in the development process are dealt with fairly. That's a very important one. They must ensure the efficient and effective operation of the council's organisation and ensure the implementation of the decisions of the council without delay. In relation to council information, they must use and secure it appropriately and not disclose that information. And of course, this is extremely important in relation to the information that councils hold. Employees must use council resources, and this is all in the code, ethically, effectively, efficiently, economically and carefully in the course of their employment. They must give their attention to the business of council while on duty, so they really should not be doing any other business whilst they're on council duty. They must carry out lawful directions given by any person having authority to give such directions. And they must give effect to the lawful decisions, policies and procedures of the council whether or not the employee agrees with or approves of them. So sometimes an employee will have their own personal view about a certain decision of the council, and the code binds them to take into effect and to put into effect any decision of the council, even in circumstances where they completely disagree. That's a positive obligation under the code. Now, later on, I'm going to go through just briefly gifts and tokens, code of meeting practice. I think I'll also talk about conflicts of interest, and I know you have something to say about that.
Yes.
But Shawn, in addition to the requirements under the code, is there any other legislative obligations for council employees?
There sure is, Simone. In addition to those requirements under the code, don't forget that there are legislative obligations under the Local Government Act. In particular, Section 439 of the Act requires staff to act honestly and exercise a reasonable degree of care and diligence in carrying out functions under the legislation. So in essence, you have a code of conduct, but you also have an overriding obligation under the legislation in order to ensure compliance. The Act also provides that council employees must abide by relevant provisions of the Code of Conduct.
Right. All right. Well, I'll just discuss a little bit about code of meeting practice. Employees must act in accordance with the code of meeting practice that's been adopted by council. During council and committee meetings, they must show respect to the chair, other council officials and any members of the public present. And they must also act in accordance with the code at any formal events of the council, which sometimes a lot of employees don't realise. Now, sometimes this can be just senior staff because they're the ones that are attending the council meetings, but sometimes formal events of councils, employees are invited to attend, and whether or not they're in their capacity as employee or public person, they really should keep a mind out for what they need to do under the code. So there's a positive obligation there. In relation to gifts, employees must not accept money or gifts of value, and they really should avoid situations that give rise to the appearance of securing favourable treatment. I've heard someone give a really, really good analogy once in relation to gifts. Some gifts say thank you, some gifts say please, and that's really the test. If the gift creates an obligation to reciprocate, or if that gift gives a sense of entitlement, or a perception that the employee is subject to influence, accepting such a gift will be a breach of the Code of Conduct. I also want to emphasise the duty in relation to conflicts of interest. All employees must disclose any conflict of interest and must appropriately manage any conflict. There's a positive obligation on a council employee to declare that conflict. So any breach of any of these behaviours or obligations will be a breach of the council's Code of Conduct, and they're more on the serious side. Shawn, can you talk a little bit about conflicts of interest for us?
Yes, Simone. As an employee of council, there is potential for conflicts of interest to arise in the course of a staff member's role. Conflicts of interest must be managed appropriately. Council employees must consider how a reasonable person who is informed about the situation would view it. In summary, a conflict of interest exists where a reasonable person and an informed person would perceive that a staff member could be influenced by a private interest when carrying out their public duty as a council employee. A private interest may be pecuniary or it may be non-pecuniary, Simone.
Well, tell us about pecuniary first.
Well, pecuniary interests are largely dealt with under the Local Government Act. However, the Local Government Act is silent in relation to non-pecuniary interests.
Right, okay.
The pecuniary interest provisions in the Local Government Act relate to certain people only, such as the General Manager. Senior staff and other employees appointed as designated person.
So I think with that, can I just interrupt, Shawn? With designated persons, they're people that have been appointed by the council as a person probably who receives a lot of information perhaps, and so they're appointed as a designated person for the purposes of that provision. That's correct, isn't it?
That's correct, Simone. So in essence, Section 442(1) of the Local Government Act sets out a statutory definition of what a pecuniary interest is.
All right.
And that interest that a person has in a matter because of a reasonable likelihood or expectation or appreciable financial gain or loss to the person.
So it's financial?
Yes.
Okay.
A breach of the Local Government Act, pecuniary interest provisions can be dealt with by NCAT.
Oh, so that's dealt with by NCAT?
Yes, it is.
Right.
NCAT can impose sanctions for any breaches such as ordering an employee to be counselled, reprimanded, recommending to council that it takes specific disciplinary action against the employee, or even recommending dismissal of the employee.
So NCAT will order that?
Yes, it will.
So they'll order that the council takes action?
Yes, it will, and there'll be an obligation to take that action. Simone, do you want to tell us a bit about non-pecuniary conflicts of interest?
Yeah, I can. I'll talk about them relatively briefly because that could be a whole other webinar. But it can be complicated as well. In a nutshell, non-pecuniary interests are private or personal interests that the council employee has that does not amount to a pecuniary interest as defined in the Act. That's basically what they are. In summary, these commonly arise out of family relationships, spouses, personal relationships, social or other affiliations, and they may also include an interest of a financial nature, which is why it makes it a little bit difficult to explain in a nutshell. The test is, pursuant to law, the law will raise a conclusive presumption of bias from the mere fact of the existence of the interest, that the interest is actually there, whether or not the staff member is of the view that it will affect his or her carrying out of their duties as an employee. There is an exhaustive list of interests that do not need to be disclosed. They're within section 448 of the Act, if you're interested in looking at them, but it's a very long list. It'd probably take me about 10, 15 minutes to read it out. Now, we've discussed the Code of Conduct and we've discussed behaviours. Shawn, how far, using your employment law experience, how far does that duty extend beyond just working at council?
It's a good question, Simone. Well, the duty to act ethically extends to the interactions of council employee with other council staff,
right,
of the council, members of the public, any councillor, in addition to the use of resources and any personal benefits an employee might obtain. So
it's a very broad-reaching set of circumstances or obligation.
It is indeed. It's very broad.
Right, okay. So we should probably now look at how breaches of the Code of Conduct are dealt with in accordance with the procedures for the administration of the Model Code, which have all been adopted, as I said previously. We need to look at what a Code of Conduct complaint is. A Code of Conduct complaint is a complaint that alleges conduct on the part of a council official acting in their official capacity that is on its face, if proven, would constitute a breach of the standards prescribed under the council's Code of Conduct. Complaints that do not satisfy the definition of a Code of Conduct complaint are to be dealt with under council's routine complaints management process, which we'll get you to explain. I think there's the two limbs. There's the Code of Conduct limb, and then there is the general procedures and whatever applies to councils, which I think you're going to explain.
That's correct, Simone.
Now, what we should probably do now is explain how Code of Conduct complaints need to be reported. And could you talk to us a little bit about that, Shawn?
Yes, I certainly can. Suspected breaches of the Code of Conduct by members of staff, excluding the General Manager, must be reported to the General Manager in writing.
Right, okay.
Now, if it's in relation to the General Manager themselves, it's got to be reported to the Mayor.
So if it's staff, it's reported to the General Manager.
Correct.
If it's about the General Manager, it's to the Mayor.
It's to the Mayor.
Right.
The General Manager is responsible for making inquiries or causing inquiries to be made in Code of Conduct complaints about members of staff. He or she may choose to make inquiries and must give the complainant reasons if this course is followed.
Right, okay, so the General Manager does not have to do anything, but the reasons need to be given for that. So that's
exactly
a choice
right.
that he has?
Exactly right.
All right.
All inquiries made into staff conduct that may give rise to disciplinary action must occur in accordance with the relevant industrial instrument.
All right, and what's that?
In this case, it's a Local Government State Award 2017, okay, which I'll talk about in a bit more detail as we go through the presentation. Or it could be their employment contract, the contracts of employment that also occur.
Okay. What about representation by somebody? Are they allowed to have somebody there?
Yes, they can. Normally it'll be their union representative, and in most cases that's the United Services Union.
Okay. Well, thanks for that, Shawn. I think we've gone through the Code of Conduct, and since you are the employment law expert, would you like to expand in relation to non-Code of Conduct issues and the legislation and awards that apply?
Certainly, Simone, I will. The main legislation that applies to local council is the Industrial Relations Act 1996, New South Wales. Now, that effectively deals with unfair dismissal claims, and it deals with industrial disputes that are notified under that legislation. The other instrument that's very important that councils need to be very clearly aware of, and that's the Local Government State Award 2017. That award sets out in a very prescribed way obligations on council and also employees, which I'll talk about now. Okay. Now, in relation to the Local Government State Award, it prescribes very clearly what an employee's rights are, Simone. Now, those rights are that employees can have access to their employee files, and they can also take copies of anything that's the content within the file. They can cite, they can note and respond to anything that they believe that are adverse on their employee file. So, for example, it might be a letter of warning that they've been given in previous years, and they can seek to take note of it. They can even make an application that it be deleted or removed from their file.
Wow, so it's really important from what you're saying now to make sure that employee files are kept in good record, that everything's on there. What about file notes and things like that?
Absolutely, Simone. File notes must be clearly documented, particularly when it involves disciplinary action that's been taken against the employee. And these documents must be made current and must be kept up to date in the employee's file.
Can I just ask a question then? So that means any employee can ask for a copy of their file?
Yes, they can.
And see what's on it. So you really need to be careful about what you put on the file?
Absolutely, okay. Absolutely. In a lot of other industries, the only way to gain access to a file, because it is technically the property of the employer, is to subpoena that file. But in this case, under this particular award, it does really prescribe the employee's rights to have direct access to the file. And they can also have union involvement at any time, Simone, during this process. And that, once again, will normally be the United Services Union. Just also in relation to suspension and investigations that are carried out when there has been allegations made in relation to disciplinary action, the employee can make an application to utilise their accrued leave during any period of a suspension. Because as you'll see, Simone, as I talk a little bit about this further, an employee under this particular award can be suspended with or without pay.
When would you suspend somebody? I mean, how serious does it need to be? Well,
that's a good question. It has to be very serious. It would be conduct that amounts to allegations of serious and willful misconduct, for example. And that might be theft from, say, a council depot, or it might be allegations that there's been an assault or something to that effect, or it might be allegations of breaches of work health and safety regulations.
And would it be circumstances where you would want the employee not to be at work? Is that taken into consideration as well?
Absolutely. Okay. There might be other people involved that were involved in the particular incident, and you want to isolate those employees, particularly as witnesses. So it's better under those circumstances not to have the employee present in the workplace.
Right.
But the other thing, Simone, is that employers also have a number of rights and obligations under this particular award. Once again, the award prescribes in a very detailed way what these rights and obligations are. And first of all, there's the right to suspend, which I briefly mentioned before, with or without pay during investigations. Suspension, it can be no longer than reasonably necessary.
Right.
So if council chooses to suspend a particular employee, there's an obligation to undertake whatever investigation it's undertaking in a speedy way, in a speedy fashion.
So they can't be suspended for a long period and the investigation take a long time. You've got to do it as quickly as possible.
That's exactly right. And the suspension can't be any more than 2 weeks, actually, Simone, under this award.
It's prescribed.
That's exactly right. It's contained within the award itself. And there's an option to extend it for a period of 7 days when the employee has unduly delayed the investigation process. And after that, it can be extended by a greater period by agreement. But once again, there are specific rules in relation to how those suspensions are conducted and investigations. an investigation should only take place if it's appropriate to do so as well. So if it's conduct that is serious, of a serious nature, like I mentioned before, it would be appropriate to undertake or to suspend the employee. If it's a minor breach of the employee's obligations, say, for example, there's been some absenteeism or something to that effect, it wouldn't be appropriate to suspend the employee in those circumstances. But generally, you'll find that suspension will normally arise in circumstances where there has been breaches of the code of conduct, breaches of the employee's contract of employment, or breaches of general workplace health and safety. Now, the suspension doesn't affect an employee's continuity of service, Simone.
Ah, right, okay.
Okay, so what that effectively means is it means that while an employee is suspended, even if that's without pay, they continue to accrue all their long service leave, their annual leave and sick leave entitlements, and it doesn't break their continuity of service. Okay. So it's important to note that. There's also the option for the employee to utilise paid leave. Now, that means that if council decides to suspend an employee without pay, again, for a serious offence in the workplace, the employee can apply to use their long service leave or their annual leave so that they're remunerated during the suspension period.
So that's an election that they can make?
Yes, it is. They can't be forced to do that, but they can certainly do that if they wish to, instead of not receiving any payment for the time that they've been suspended for. Now, Simone, the other thing that the award prescribes in some detail, and council has to get this right, is in relation to conducting workplace investigations, because the process itself does have some teeth.
What governs that?
Well, the award in particular, it sets out specific procedures that the employer must follow in relation to conducting an investigation. And in essence, if council fails to follow those guidelines set out in the local government state award, then basically that can be used as evidence that they haven't complied with the award. And what I'll talk about a little bit later on is the effect that that could have on an unfair dismissal claim. If an employee is subsequently terminated and the employer hasn't complied with the investigation process under the award, that non-compliance in itself can assist the employee's case in arguing that they've been unfairly dismissed.
So you're going to go through the steps now?
I will.
All right.
I will. So just in relation to suspending an employee and conducting an investigation, it has to be unsatisfactory work performance or conduct that the employee may investigate that's serious enough to warrant an investigation, as I mentioned before. But generally when an investigation's conducted, Simone, it's like any other investigation. It's an inquiring process. It's collecting information and ascertaining all the facts. Because we've got to remember that this could lead to a situation where an employee's job's on the line. So it's important to get the investigation process right. Now, when deciding to investigate, the employee needs to consider the seriousness of the unsatisfactory work performance or conduct. Like I said before, you wouldn't conduct an investigation in relation to sporadic absenteeism that's showing a pattern. Right. That would amount to disciplinary action in itself. There would be no need. But if it was a serious breach of work health and safety, for example, there would be an obligation to carry out an investigation in relation to that particular matter, not just from a disciplinary perspective, but also in relation to properly managing work health and safety in the workplace, particularly given that council employees often operate a lot of heavy machinery, etc. Potential implications for undertaking an investigation and mitigating factors. So council has to take into account factors that might be affecting the employee, such as illness or incapacity, or it might even be something that's such as domestic violence or something that the employee is experiencing that's quite horrific. So the council needs to take into account all these matters when it seeks to investigate. And I also believe that it's necessary to offer employees who are being suspended or there's an investigation in relation to their conduct the option of utilising an employee assistance program, Simone, where they can seek independent counselling at no cost to them, and it also seeks to mitigate counsel's situation in the process as well.
Right. And so these are contained, you say, within the award. Are they guidelines? Are they rules? Are they...
They're actually guidelines, Simone, in relation to conducting investigations, but I would say that they're higher than that.
So they're not just a guide?
They're not just a guide. Essentially, if the guidelines are not followed, then that can be used as evidence in itself in an industrial tribunal to demonstrate that the employer has either failed to conduct the investigation in a speedily fashion, or it simply hasn't complied with due process and given the employee procedural fairness.
So they've got teeth. They're not just guidelines.
They've got teeth. They're not just guidelines. And time and time again in unfair dismissal matters, I've seen where investigation processes have not been followed. But in this particular case, you've got an award, the local government state award, that actually dictates the process that must be followed.
Right, okay.
Now, in relation to the award, once again, the award contains disciplinary procedures, Simone. So it doesn't just set out the right to suspend, the right to investigate, and the procedures that go along with actually doing that, but it also contains specific provisions in it in relation to conducting disciplinary matters against employees.
So again, these are steps that you must follow?
Steps that the council must follow.
That's right.
Must
sure.
follow. Otherwise, if they're not followed, it could amount to a breach of the award, and it could amount again to a procedural fairness issue arising in defending an unfair dismissal claim or in an industrial dispute situation, which I'll talk about in a little bit more detail in a moment. But effectively, what happens initially in the disciplinary process under the award is that there is initial discussions with the employee about the unsatisfactory performance or conduct, and there's an emphasis on including measures to really assist the employee. So it's just not a matter of sitting the employee down and saying, you know, you haven't complied with council's policies and procedures, you haven't done this or that. It's also a matter of putting in place a plan that will genuinely assist the employee to improve to a satisfactory standard. So that's actually specified in the award. Now, disciplinary action can take place against employees in a number of circumstances, but commonly neglect of duties, breach of employment obligations, absenteeism is a big one, Simone.
So do you think that a common occurrence in the councils that you advise for, absenteeism? Yeah,
I really do. I've seen that occur quite extensively.
And what is that, just long absences of leave?
Yes, it might be sporadic absenteeism, or it might be absenteeism after a weekend, like on a Monday or a Friday or something like that. And it's just employees who are seeking to utilise all their sick leave. One has to be careful where they produce medical certificates, because effectively the employee is complying with the industrial award where they bring certificates. But if patterns of sick leave are occurring, then that can be managed through a disciplinary process.
Right.
But it's a matter of being very careful in doing so. Now, one of the other things I wanted to mention, Simone, is that where the initial discussion's taking place under the award as it's prescribed, it's very important that detailed notes are taken of that particular meeting. And that gets back to what I said earlier about the fact that employees can have access to their personnel files.
So that should go on the file?
Yes, it definitely should. Employees can have access to their files and they can take copies of it. They can make annotations on any notes that are contained in their file.
Really?
Yeah, it's quite prescriptive in that regard. Now, just some other reasons as to why disciplinary action might be taken against employees, Simone, is non-compliance with safety standards, and a written record, as I said, must be placed on their file. And they can be asked to sign the written record. And
what if they don't?
Well, I've seen an instance where an employee has actually screwed up the written record and thrown it in the bin. That's fine. It just has to be gotten out of the bin and put back in the employee's file, and you would make a note on that annotation that the employee actually sought to screw up the record, and it's been placed back on file.
Right, okay.
So the warning still stands. It doesn't mean the warning no longer exists. Just
when
because
it ended up in the bin.
Yeah, exactly right. just in relation to a continuation of the disciplinary process under the award, we then move to the next step, Simone, where there's been further non-compliance of workplace performance.
So you've gone through the investigation, you're up to the disciplinary process.
Yep.
And it's the next step.
That's right. So we've gone through the process where they've been given an initial warning, which is a note on their file. Now we're going to a more serious type process where, once again, we're warning them, but it's a formal warning.
Right.
And that will need to be in writing. So it's, again, having a meeting with the employee, giving them an opportunity to respond to the allegations that are being put before them. It's also giving them a right to have a support person with them. Normally it might be a union delegate.
Can it be anybody else, though?
It could be somebody else,
right.
Yes, within reason. And what I mean by within reason is that a support person has the role of being a support person. They don't have the role of being an advocate on behalf of the employee, Simone. So
could you get a lawyer in?
They could get a lawyer in, yes. But once again, most lawyers would know that the role of the support person is to sit silently, maybe help clarify any questions that are put to the employee, but certainly not act as an advocate for that employee during the course of that disciplinary meeting.
I've just thought of something. Would that make that solicitor a witness in any proceedings?
Yes, it could. It could indeed. So where a lawyer is actually used as a support person, and the same applies with counsel as well, that lawyer could be used as a witness in any unfair dismissal proceedings or dispute proceedings. Now, once again, Simone, employees have the right to cite any warning that's placed on their file or that they're given and make notes and take copies of it.
Yeah, I didn't know that.
Well, it's all prescribed by the award. And look, most other awards in other industries don't have this sort of prescription.
Oh, is that right?
That's right. But this particular award does. Now, Simone, what actually happens after the second written warning's been given to a council employee if they still haven't improved or they haven't, they might have improved for a little while, for example, and then their performance again goes downhill in relation to the issues they've been spoken about? It could be time to issue them with a final warning.
Right.
Now, a final warning, once again, is given to them expressing what the unsatisfactory performance or conduct has been. It needs to give them an opportunity to improve in relation to that conduct. Again, they can have a support person there during the course of the meeting that they're given the warning in. It's a matter for the employee. And it's very important that they're in writing. And if they're not in writing, then that could be an element against procedural fairness. So procedural fairness might not be followed to its course if they're not in writing. Now, it's important to note that in a lot of councils, there's union delegates, and those delegates have a right, without loss of pay, for a reasonable period of time to sit in on an employee's disciplinary meeting, provided that there's been approval given first for their time to be there away from whatever work they're doing.
And who's the approval from?
It would be whoever the delegate's manager is.
Okay.
Yep. Now, Simone, there are a number of penalties that are actually set out in the local government state award. So it doesn't just prescribe processes in relation to investigation and suspension and disciplinary action, but it talks about the actual penalties that council can actually take against the employees. Now, the first consideration is demotion to a lower paid position or lower salary band. That's in accordance with the classifications that are set out in the award. But if council does decide to demote Simone, it must give a 2-week period before actually doing that from the date of the demotion. Right. So there's a grace period of 2 weeks before the demotion actually kicks in or the salary reduction kicks in. They can suspend the employee, and we've already talked about that suspension normally occurs where it's a more serious form of conduct that the employee's engaged in. The employee can also be terminated. Now, we've got to remember that termination of employment is the ultimate sanction.
Yeah, it's for very, very serious.
It's got to be very serious. So you either get to termination after the employee's received a final warning and still hasn't improved, or the employee engages in some form of conduct that's serious, that doesn't warrant following the first and second warning process, because there is a slight degree of flexibility in this award to actually do that, but the onus will be on the employer to demonstrate that it had the right to proceed directly to termination. And
I was going to put you on the spot and say, what kind of activity could that entail?
okay, well, the more serious type forms of conduct would be breaches of work health and safety, for example, or it might be a theft from a depot. It would be something of that nature that would be of the more serious offence. Now, that might be dismissal for unsatisfactory conduct in the workplace, in which case we would always recommend that the employee receives notice under the award. But council also has the right to terminate an employee for serious and willful misconduct, and that's summary dismissal. That means terminating the employee immediately without any notice. Simone, I might just also talk about Section 440D of the Local Government Act, and there's a right to suspend a member of staff from duty in relation to conduct that amounts to serious corrupt conduct under that legislation. Now, serious corrupt conduct has the same meaning as the Independent Commission Against Corruption Act, 1998.
Okay, so the ICAC Act.
The ICAC Act, that's correct. So there's that, not only is the right to suspend under the award, but there's the right to also suspend under that section of the Local Government Act, the Local Government Act, where it constitutes that particular conduct. Now, the conduct that might constitute a serious indictable offence in connection with the exercise of purported exercise of the duties of a member of staff.
Right.
So it has to be really serious in order for that conduct to come in, and it might be a breach of the code of conduct that you spoke about in some detail. Now, in relation to the Industrial Relations Act 1996, I wanted to talk about that a little bit, because the whole importance of getting this prescribed process correct under the Local Government Act is important, because it can, if the employee is ultimately terminated, the employee can bring an unfair dismissal claim under Section 84 of the Industrial Relations Act, Simone. Now, that means that the employee could either seek reinstatement under that legislation without loss of pay, or with loss of pay, or it could also the employee could seek re-employment, or they could seek financial compensation. So it's very important, if the process under the industrial award isn't followed correctly and procedural fairness deficiencies do arise, it'll give the employee an opportunity to bring a claim under that piece of legislation. Now, Simone, I want to talk a little bit about grievance and dispute procedures as well that are contained in the award. Once again, a fairly prescriptive process that the award sets out. Now, in relation to the grievance dispute process, disputes need to be dealt with as close to the source as possible, Simone. So that would normally involve an employee dealing with the matter with their supervisor, for example, or discussing it with management. And it might be to do with an issue involving a reclassification of the employee under the classification structure of the award. It might deal with disciplinary action that's been taken against them. And that's why it's very important to make sure the employee's file has clear and concise notes in relation to what's occurred.
Yeah, that sounds like it. It's a really important point to make.
It's an underpinning situation in relation to that, Simone, absolutely. Just dealing with the disciplinary procedure in a little bit more detail, if the matter remains unresolved, it's referred to the head of department. And at any stage, the employee can engage the union. Okay, which is normally the United Services Union, as that tends to be the union that covers most employees in the workplace. But that meeting must occur as soon as possible. And if it's unresolved at that stage, Simone, the General Manager gets involved. And the General Manager will provide a written response which needs to include any reasons for not implementing any remedy or suggestion that the employee or their union representative has raised. Now, the employee or normally their union representative can notify a dispute in the Industrial Relations Commission at any time, Simone. And it can be used as a tactic to circumvent, in my view, industrial or disciplinary action that's been taken against an employee in order to involve a third party such as the Industrial Relations Commission of New South Wales to facilitate a compulsory conference under Section 130.
Can I just ask you a question? Should normal work continue whilst that dispute procedure is being followed?
Yes, but only as far as practicable. So what I mean by that, if it's a dispute in relation to work health and safety and the workplace isn't safe where the employee has been engaged, well, then that might mean that normal work can't continue.
Right.
But it could be a situation where the employee could move to another depot something with consultation.
Right.
Now, I'll just talk briefly about Section 130 of the Industrial Relations Act. It's the dispute provisions of the Act, and that's the legislation that employees or the union representative can notify a dispute. The Commission has the power to, first of all, conduct a compulsory conference, and it also has an obligation to get to the bottom of the issues. It can make recommendations or it can give directions during that time. And if the dispute isn't resolved, it can ultimately make orders in an arbitrated matter.
Okay. Well, look, I want to make sure there's just a few minutes left to answer some questions because I think we've had some come through. Thank you for that detailed analysis, Shawn. You actually taught me a few things that I didn't know. Are there any key points that Council should take away today?
Thanks, Simone. There is. First of all, it's been my pleasure. What everyone needs to remember is how prescriptive this award is in relation to disciplinary process, the process of investigation and the rights of obligation of counsel in these types of matters. For example, suspending employees. The key takeaway in relation to getting it right is to ensure strict compliance with the processes set out in the award to prevent industrial disputation, and to also prevent a situation arising where it's necessary to terminate an employee's employment and that employee brings an unfair dismissal claim and the employee, the council has not clearly followed the precise prescriptive disciplinary procedure set out in the award, which can amount to some omissions and procedural fairness. Now, Simone, we do have some questions that have come through from the audience. I have a question here from James. James's question is as follows. Where the employee's conduct warrants disciplinary action, is council required to follow the disciplinary process in strict order, or can it modify it depending upon the conduct concerned? Well, the answer to that is that it can modify the disciplinary action, Simone. But for example, it might be, as I mentioned before, it might be conduct that is so serious that it might mean it can jump straight to a final warning stage rather than following the first warning, the second warning. We have another question here from Michelle. How are unfair dismissal provisions under the legislation different from the dispute provisions you talked about? That's a good question. With the unfair dismissal provisions under the legislation, Michelle, what the differences are is this, and it really comes down to the remedies. First of all, with unfair dismissal provisions under the Act, the employee can seek reinstatement with or without back pay, or they can seek re-employment. Or the Commissioner has the power to award monetary compensation. Now, that's in contrast to the dispute provisions where if an employee is terminated during the course of a dispute, the employee can only be reinstated. The re-employment and the monetary compensation alternatives do not apply.
Right. I think we're just out of time. So what I'd like to do is thank you for taking the time to join our webinar today. We really hope that you're able to relate to the discussion and that you actually were able to learn something from it. And I was grateful that I could introduce Shawn to you.
Thank you, Simone.